Tessa Youngner here with News 5 at 5. It is Monday, June 26, 1978, and today we're covering the court case of Bakke versus University of California. We're going to head to our field agent, Tessa Youngner, who's at the court case right now with their decision. Hi, this is Tessa Youngner here. Thank you, Tessa. We are outside the very courtroom where they're coming up with a decision right now on the case of Bakke versus University of California. Now, we've been covering this case for a while, so let's take a flashback at what the events that have led up to this case.
Darn it! I got rejected again. I am 35 years old and I've been rejected from 12 medical schools. You know, I'm just going to apply to University of California because, you know, I just feel like that's a really credible school. I mean, like, I don't know. I graduated from University of Minnesota with 3.5 GPA. That's good. That's good. And I've been captain in the Marine Corps. I've worked for NASA as an engineer. I have a great MCAT score. I think I can get in. Yeah. Yeah, I'm good. Today's the day. That's weird. According to the statistics, I should have gotten in. You know what? Maybe it's just a bad year. I guess I'll just try again next year.
Yes! Yes! Yes!
You know, it's a year later since my rejection. After looking at those statistics and seeing that my MCAT score was a 72 and the people that normally get accepted is a 69, I feel like I can do this. You know, I've been on 2 interviews, one with a student, one with a professor. I think they went well. Yeah, I'm gonna do this. It's here.
Yes! Mom! Look at this!
Hi, this is Bakke. Is this the Office of Admissions at University of California? Yes, I was calling because I have reputable information that proves minorities got accepted over me. They got accepted because of their race. I had higher test scores. I was more qualified than all of those students that got accepted, and I just wanted to say that this is not right, and I am going to sue you.
So as you've just seen, Bakke did apply to college 2 times and was rejected over other minorities that didn't score as well on tests as he had. He is suing the court. He sued the California Supreme Court and won, but now it's being appealed to the United States Supreme Court. Let's see what the decision is.
Justices of the Supreme Court, I would just like to point out that my client here, Bakke, was denied equal protection by the law due to his race. He met all the college requirements. He went above and beyond. He even called the college to see what was wrong, but they couldn't give him a straight answer. You want to know why he got denied? Affirmative action. Ladies and gentlemen, affirmative action is against the Constitution. It is unconstitutional and it is unfair. The 14th Amendment of the Constitution states that everybody is protected by the law and everybody is guaranteed equal rights. But that's not what's going on right here, is it? Affirmative action violates the Equal Protection Clause. It is where others more qualified may not get a position they desire or they deserve. Why? Because minorities are getting that position that aren't even qualified. That here is what Bakke is experiencing. Bakke met all the qualifications. He met the GPA requirements, had an outstanding MCAT score, definitely had recommendations, yet he still got denied. Why? Ladies and gentlemen, this is unjust.
I think that race should also be a factor as long as people also consider economic backgrounds or educational backgrounds. Did you know that fewer than 10% of African Americans that achieve to be medical students actually make it into their medical programs? And that's because they don't have the affirmative action program that University of California has. And I think affirmative action has taken huge leaps and bounds into incorporating people of color into the medical business. In order to get beyond racism, we must first take into account race. There's no other way, because when you're just straight up talking about white students versus black students, there's obviously more white students, and affirmative action tries to take care of that. The special admissions program of UFC Davis Medical School also did not consider only those of minority races, but they also considered white students who are struggling educationally and economically. These are things that all colleges look at, and so to say affirmative action is unconstitutional eliminates a whole category of people that need help getting into medical school. That's all I have to say.
Justice Lewis Powell of the Supreme Court contend that any racial quota is against the Civil Rights Act of 1964. I believe that if race is to be considered, other factors should be considered as well. Race shouldn't be the only consideration. Also, Bakke should be allowed to attend the University of California's medical school because he was well qualified and more qualified than other races. Any racial quota is a violation of the 14th Amendment and also is a violation of the Equal Protection Clause. I believe that affirmative action should still be in place. I believe that in universities, any racial quotas that are too strict are also a violation of the 14th Amendment. There should be some sort of diversity in schools, however, other factors should be considered as well. The race is not the only determining factor, and that is all I have to say.
Good Marshall, as a part of the dissenting opinion, believed that having quotas doesn't go against the Civil Rights Act of 1964. If anything, I believe that having specific quotas for colleges to follow for acceptance of colored people allows for more diversity in colleges. The majority opinion believes that having such quotas is against the Civil Rights Act of 1964. We both believe that Alan Bakke should have been accepted into the University of California, and both believe in affirmative action, but I believe that quotas would enable more diversity than affirmative action itself would.
Well, you heard it here first. Alan Bakke is allowed to attend the University of California, Davis, but affirmative action still stands. According to the decision of the court case, there are no quotas allowed in college admissions process, but your race can be a significant factor in the admissions process as long as there are other factors still present. This is Tessa Youngner signing off from News 5 at 5. Hi, this is Tessa Youngner here for News 5 at 5. Restart it. It is Monday, June... Shit, what's the date?
Darn it! I hate God. I just don't understand. I graduated from University of Minnesota with a 3.5 GPA. Bella! Okay, we're gonna... Wait, there's a car coming.
Who cares?
Today's the day. Oh shit, no, go back. It was supposed to be long. Hello, is this the office of... at the University of California? Yes, this is Alan Bakke calling. Turn the fuck... Yeah. Yes, I am calling because I have some, what do I say?
We've been covering this story for a while, so let's go take a flashback of what has been decided up to this point. Shoot, it's screen.
Justice of the Supreme Court.
Yep.
I'd just like to start off by saying my client here, Alan, I was going to say Alan Blake. I'd just like to start off by saying that my client here, Alan Bake, was violated. Wait, not violated, was not the...
She said Alan Bake.
I think that schools should be able to have the right to decide whether or not race is a factor and whether they accept students or whatnot, as long as
Their races. Wait, cut. Sneeze. Wait, cut.
He's allowed to go to college, but affirmative action still stands. Dream on. Well, you heard it here, folks. I forget the rest of it.